Hello, everyone, and welcome this fall to our virtual seminar series. Sorry, it's not the summer anymore. I'm Ashley Jordan. I'm a partner in our labor and employment group here in Denver, Colorado with Husch Blackwell, and our entire group is so happy to have you here today. We have attendees from all over the U.S. To hear about our Colorado employment law updates. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. And if you have any questions during the webcast, please submit them via the question box. We're going to do our best to answer as many questions as we can as time allows. A PDF of the presentation and other resources are available in the resources folder. This program has been approved for HR and legal education hours. So to report your hours, use the CEU icon at the bottom of the screen. And then tomorrow, a certificate of attendance, including course numbers, will be emailed to you along with a recording of the webcast for your watching and sharing. Towards the end of the program, be sure to complete our short survey. This is actually really important because we're always wondering what's of most interest to you all as employers, and we really do use your feedback to plan future seminars. So that's all for the housekeeping items, and now it's time to get started. So today we have 4 presentations. We will take a very short break in between each presentation if you need to step away for a minute or two, and we'll have a few poll questions as well during that time. But right now we're just going to go ahead and dive in with presentation 1. So I'm really happy today to have Molly Hobbs present with me. Molly is also a partner in our Denver office of Husch Blackwell, and she's an employee benefits attorney. So she has special expertise that will be helpful to this presentation today. So what we are going to be talking about is family and medical leave insurance, also known as FAMLY. And I feel like we've been talking about this for a while because the Colorado voters voted on this in November of 2020. So it's literally been 3 years that we've been trying to get all of you as clients up to speed on and make sure that you're meeting all of the deadlines. So I'm hoping that none of this is news to you. But I have here on the slide here, I just kind of briefly wrote down what should have already occurred. And so hopefully, again, these are things that you've already taken care of. But basically, I'm hoping that by January 1st, earlier this year, that you already registered with the state, you started collecting premiums, and then at the end of the first quarter, you submitted payments and wage reports. Just a few days ago was the deadline for the exemption for a private plan if you want to take advantage of that. And I know that's really what Molly's going to be talking about in a few minutes. But again, that deadline has passed. So if any of these are alarming to you, then we probably need to talk offline. So what we want to talk about is just nuances with this, and because I'm assuming that you all know what FAMLY is all about. Very brief summary: it allows for paid leave for employees. The employee gets 12 weeks of paid leave in one rolling calendar year, 16 weeks if the need for the leave relates to pregnancy or childbirth complications. As far as events giving rise to family benefits, it's birth, adoption, or placement through foster care of a child for the employee's own serious health condition, or for the employee to care for a family member with a serious health condition, qualifying emergency leave like military service, and to address immediate safety needs such as sexual assault or domestic violence. Covered individual, most of you will have, all of your employees will likely be eligible to take advantage of the leave. But just as a reminder, the employee needs to have worked at least 180 days for you, so 6 months, and the threshold for wages is very low. They just have to have earned $2,500. There's not very many of you on this webinar that have just a very small number of employees. But if you have under 10, then you don't have to contribute. But as long as you have one employee, FAMLY applies to you. So just wanted to make sure you know about that. What is next? Where are we in the process? So effective January 1st, in just under 2 months, employees will be eligible to get the paid leave. And so that's where we are. The leave cap is currently set at $1,100 per week. And like I said, it's normally for 12 weeks. That's the maximum. So I want to let Molly take over now and talk about the private plan exemption.
Thank you. Again, my name is Molly Hobbs. I'm an employee benefits and compensation attorney here in the Denver office. So this private plan exemption under the family provisions in Colorado implicates my world a little bit. So Ashley and I gave a remarkably similar presentation last year, a little bit earlier in the year. And at that point in time, Colorado had only issued proposed regulations on the private plan exemption. So things were still fairly up in the air. Subsequently, thank goodness, they actually came through and issued real rules and guidance. So we got a little bit more information, but nothing was too surprising. The proposed regulations were generally adopted. So just to remind everyone at a very high level, employers can satisfy their family obligations under the state rules by adopting their own private plan. There are some nuances there, and I'll talk about them a little bit on my next slide here, which is there are some challenges with the private plan exemption. So it's not as easy as just saying, well, we cover family leave, so we're good. So actually, under the Colorado law, you have to provide equivalent benefits. So you actually need to go through and very carefully look through everything that is required under the family leave laws in the state of Colorado and make sure that your private plan is in compliance with all of those laws and providing equivalent benefits to the state law. So that's kind of challenge number one. The other challenge was, and we knew this from the start, we knew this last year, is that the state came out and said, it's cool if you want to adopt your private plan, but by the way, you're going to have to pay premiums for the entirety of 2023 and then submit your private plan to us. And then once we approve your plan, then you can get a rebate on all the premiums that you paid in 2023, which was a little uncomfy for some employers. I don't think people were all that excited about it, although obviously some folks have moved forward. Also, at this point in time, there are actually insured products on the market. So for employers who, and I guess is a little bit of background, just like any other benefit plan, you can either find an insured product or a self-funded product. So you can now go out and get an insured product that is in compliance with the family leave laws under the state of Colorado if you want your own private plan. You could also do your own self-funded plan as an employer, although that would mean that you would have needed to, at least if you wanted to get a rebate on your 2023 premiums, put a plan together, submit it to the state, you have to pay an application fee to the state to get it approved, and start moving forward from there. So those were your two options. And that was the other kind of challenge with this entire process is that you had to apply, there's an application fee, and also you have to reapply. So this application it's not like you get it approved and you got a green light for years and years. You have to reapply every 8 years. So now, Ashley and I thought it would flow well because Ashley and I sit in different practice areas here and actually rely on each other quite a bit. So we thought it would flow well if we actually just asked questions to each other for the benefit of our audience. So I'm going to start. So Ashley, can an employee apply for benefits in 2024 for a condition that began in 2023?
The answer is yes. This is actually a question that I've gotten a few times from clients already, and the answer is yes. So even if the condition started in 2023 or even before that, if it continues into 2024, then the employee is eligible to collect benefits and take the paid leave in 2024 for that ongoing health condition.
Excellent. So my second question for you is now that the opportunity for paid leave we're only a couple months out at this point, is there anything that employers should be thinking about in terms of alerting their employees about their right to utilize family benefits?
Good question. And again, this is something that's come up a lot in the a lot has come up in the preparation stage for this taking effect in January. But hopefully by now you have incorporated family into your training, into handbooks, into policies. You've alerted HR as to how it all works. Um, there's required postings. Um, but also, it's really important to understand this is obviously an extremely employee friendly benefit. And the government wants the employee to understand that they have this right available to them. And so if the employee comes to you and says, you know, I'm experiencing this condition, the employer actually has an affirmative obligation to provide a reminder to the employee regarding the benefit and the availability of it. And so again, that goes to training and making sure that HR or even managers who might take those types of questions or engage in those kinds of conversations are aware of this benefit and that employees have the right to use it.
Interesting. Another question. So, and this is an area that I get tripped up on all the time. Many employers and myself are confused about the interplay between FMLA and family. Can you provide some guidance to us all?
Sure. Well, among other things, the acronyms are very similar, so people do get tripped up on that quite a bit. So family, above all, is a paid benefit. FMLA is not paid, it's unpaid. I think one of the most important things to understand about how these two work is that the family benefits and FMLA run concurrently. So there's not going to be a situation where an employee can take time off as part of family and then they take FML leave after that. So that would be stacking, and they're not allowed to do that. Again, FMLA provides unpaid leave, and family is paid leave. And just as a reminder, family generally isn't going to be a full wage replacement, but it's partial wage replacement. And then also, family benefits are often available to an employee who wouldn't even be eligible for FMLA. So the threshold of when you can take advantage, just like I said a couple slides ago, it's pretty low. It's $2,500 in wages, and it's only 6 months of employment. So a lot of employees might, newer employees might be able to take advantage of family. Here I go. When FMLA is not available to them. I think those are pretty much the main things that employees are going to ask about and that employers ask us about. I think the other important thing in terms of similarities is that they both provide job protection, and obviously you can't retaliate against somebody for taking the leave, whether it's FMLA or family. And so you want to be really careful that there's no appearance that that's what's happening or that that's not actually happening in reality.
Thank you.
Mm-hmm.
So, and this is another one, because obviously providing paid benefits for family leave isn't an unknown concept for employers. So is it possible that an employer can require an employee to use other paid time available, PTO, what have you, before the employee is receiving their family benefits?
So I would say that this question might be one of the most important ones to know the answer to, because this is where I really think employers could get tripped up. So the statute is crystal clear that under no capital N, capital O circumstances shall an employee be required to use or exhaust any accrued vacation leave, sick leave, or other paid time off prior to or while receiving family benefits. One thing to consider, and the employee may ask you about this, is that employees can use paid time off and use that payment to supplement what they're getting from family. So in other words, with family, they're often getting partial wage replacement. They can use paid time off in conjunction with family to get full payment on their time off, but they cannot be required to exhaust that paid time off before they use the family benefits. So another thing is, just in case you have an employee who's asking you, you can't have an employee receive more in compensation than their average weekly wage. In other words, they can't use their paid time off and family to get more than they would have gotten if they were actually working. So now I want to ask Molly a couple of questions about the private plan exemption. So Molly, I know that this deadline was just a few days ago. What can an employer do if they want to still apply for that exemption for a private plan? Is that possible?
Right. So yes, we had this Halloween deadline, and so the short answer to your question is yes. So employers are not foreclosed from adopting private plans going forward. The deadline that was a couple days ago was meaningful because the state, when rolling out this program, because they kind of punted on the private plan exemption and said, okay, everybody's got to start paying premiums through 2023. The deadline was meaningful that if you as an employer, if you applied and received the private plan exemption in 2023, you got in before the 10/31/23 deadline, you would be able to receive any of those amounts that you've paid in premiums to the state, you'd be able to receive them back. So going forward, this just means it's not to say that you as an employer can't have a private plan. You can still move forward with the private plan, but you're still going to be paying premiums to the state and you don't get them back. So that was the meaningful deadline. But just because we are past the deadline doesn't mean that you as an employer cannot have a private plan. We still have that available to employers. And again, you can move forward whether you want that as an insured product or a self-funded product, a plan that you would ideally work with your legal counsel or someone to draft a plan.
Great. One other question that actually I've heard a lot of buzz about. People are wondering, and it's employers and employees alike, they're wondering, are these family benefits subject to tax, federal tax, state tax?
That is a really good question. So we know, and we've known for a long time, that the state said that these are not going to be taxable benefits to individuals in Colorado receiving the family benefits. And then the state has said, but we don't know about the federal government. And the reality is the federal government hasn't told us. So the answer is, and still is that we don't actually know what the federal government is going to say with respect to taxing these benefits under the federal tax guidelines. So stay tuned. As you may or may not know, it takes the IRS a long time to do pretty much anything. So we may not know for a while, but at this point in time, we don't actually know whether it's going to be taxable to employees. And the state's resources are pretty explicit about that as well, that they say it's not taxable in the state of Colorado, and we'll see with the feds. So we have a few more minutes, so yeah. I think we'll have a little. I'll go ahead and ask Ashley a few more questions. So, and this comes up a lot now because in this post-COVID era, now we have remote workers all over the place. So what about individuals who are working remotely? Would families still apply to them?
So we have obviously a lot of multi-state employers, and questions about remote workers come up all the time, almost every day. So the specific question Molly's asking me is, does family apply, if I have even one worker in Colorado, or if somebody's working in Colorado, but we're really not a Colorado company? And the answer is yes. You have to be really careful here. If you've got a permanent remote employee who performs work in Colorado, even if the employer doesn't have a work site in Colorado, that employee gets family benefits. And so you have to, again, make sure they understand that these benefits are available to them. And you have to, do the wage withholding and pay the employer contribution, assuming you have 10 employees or more, and all of that. So the answer is yes. You really have to be careful with those remote workers.
That's interesting. And then how does an employer know when an employee on family is expected to come back to work? Are there set time periods?
Yeah, there's not set time periods. Obviously, the hope is that there's some communication between the employee and the employer about when the employee is coming back to work. But in addition, the division does have an online portal, which is how all of this works between employers and the division. And when an employee files a claim and provides information, they will be required to include information about an anticipated return date and the employer is going to be able to see all of that. And so there's going to be all kinds of documentation in that portal that the employer really should be checking on periodically. And I guess this also just brings up something I wanted to mention. It's not in the slide, but there is a lot of information on the website with the division, and it's family.colorado.gov. And there is probably more information than you would ever want to look at, but there's all kinds of resources. There's copies of the poster that I talked about that's supposed to be posted. There's a lot of Q&A documentation. There are actually recordings of webinars and seminars that the division has done. Everybody's trying to make sure that employers really have all the information they need, because this is something that's, even though we've been talking about it for a while, it's finally starting to take effect. So it feels kind of new, even though there's been some background noise for a few years.
Right. I think we've probably got time for one more question.
Okay.
What happens if an employee changes employers?
So this is something that an employee might ask you, and it's also probably good for the employers to know this as well. So the benefit follows the employee. So the benefit's portable. So if an employee changes employers, that benefit goes with that employee to the new employer. And so all of the limitations and, for example, you can only use 12 weeks in a rolling calendar year. If you've used, some of them at one employee and you're still in that rolling calendar year and you're at the next employer, then you can use the remaining amount of the 12 weeks, but it doesn't start over again. And so that's something that, if you're hiring somebody and they want to take family benefits and they're kind of a new employee, then you want to take a look at that so that you're not running afoul of somebody getting more benefits than they're entitled to.
Interesting.
Okay, well, I think that concludes our first presentation. Thank you so much, Molly. And now we want to go to our first poll question before I introduce our next speakers. Let's see. So here's our question. Do you have Colorado-specific agreements or policies with your Colorado clients? And so your options are yes, no, or I'm not sure. Give you a minute to put in your answer. Still waiting for the results. Okay, here we go. So yes came to 49%. No was at 16%. And this one is a little alarming. 35% of people aren't sure if they do or not. And for multi-state employers who have operations everywhere, I can understand that. But thankfully, we have Chris and Marina to talk next about updates that we have in the Colorado law context. And Chris is a partner of mine in the Denver office of Husch, Blackwell, and Marina is our newest associate in the labor and employment group here in Denver. So I'm so excited for the two of them to take it over.
Well, thank you very much, Ashley. And in particular, I would like to thank you for not asking a poll question about whether we've loaded the correct slides. That is being addressed. Thank you all. That was very helpful that we just heard from Ashley and Molly. One thing that we want to provide, and this is kind of the par for the course when we do these types of seminars, is we like to provide legal updates on the recent changes to Colorado law. And I can remember when I first started practicing, a lot of times those changes would be kind of nuanced decisions from the District Court of Colorado or an interesting decision from the 10th Circuit or the Colorado Supreme Court. And then kind of the political tenor of Colorado has changed such that we now have laws that are being passed on a yearly basis that have a very large substantive impact upon employers. It's not going to surprise anyone to know that those changes are going to be employee friendly and will usually constrain the discretion that employers have. So, in general, I'd say that 2023, the legislative session in Colorado runs from January until May. The legislative session this year that passed, we probably did not have as sweeping of laws as perhaps some of the previous years, but that doesn't mean that they are not very impactful in terms of the areas that they directly address. So I will turn it over to Marina to talk about our first one.
Thank you, Chris. I'm happy to be here with this community today. So we're going to start with concerns regarding age discrimination. This year, the Job Application and Fairness Act was passed, going into effect July 1st of 2024. Essentially, this just re-solidifies that employers should not be asking about age or date of birth information in their job applications. So again, no age or date of birth, but also no age proxy information as well. So that could be dates of attendance or dates of graduation from an academic or educational institution. Employers still may ask about certifications or other documents, transcripts that would include this age proxy information, but employers must let the applicants know that that information can be redacted before being submitted to the employer. Now, employers are still not prohibited from asking about information that pertains to age verification for bona fide occupational qualifications or where federal or state laws require it. But again, they cannot ask about the specific age of the applicant. It has to just be a verification that that the applicant meets that minimum age requirement. And so the Act does not provide for a private cause of action, but still significantly, it does make it so that applicants who do encounter situations like this, they can submit complaints to the Colorado Department of Labor and Employment, which we will refer to as the CDLE. And that provides for a step enforcement scheme of penalties up to $2,500. And then each one of those job applications is its own specific violation. So these can certainly add up. So we definitely encourage employers to be reviewing these before this goes into effect next July.
All right. And so I get the opportunity now to talk about some of the big changes that have happened in Colorado that are affecting things like benefits and policies. As a reminder, Colorado became one of the states that implemented a paid sick leave law. A lot of our clients who are on the call today are based in the Midwest, and they're aware that most Midwestern states don't have that sort of requirement. As Husch Blackwell has expanded its footprint, we've also, though, been starting to advise in multiple other states that are involved. And what we know is that right now, Colorado is one of 14 states that provide for a paid sick leave law. To rehash what you probably already know if you have employers in the state of Colorado, this is required for 1 hour of paid sick leave for every 30 hours worked, up to a maximum of 48 hours, so 6 days of sick leave. And it's generally speaking, is applied to 5 broad categories, and that law has only been in effect for about 2 years now. Now, what are the categories? It's kind of what you would anticipate. It's going to be an illness or a health condition. It's going to be preventive medical health care or treatment, anything related to domestic abuse, the care of a family member, and then there was a special exception because, of course, this passed during COVID, also for public health emergencies. Now, what are the rubs? What are the issues that we've seen a lot of employers struggling with? And the ones that I'm going to talk about, I will say I've fielded multiple questions on these topics, okay? So the first issue that we have seen is just the misuse of paid sick leave by employees. I am not trying to be pessimistic. I recognize that it is an unusual employee that is going to truly try to take advantage of the sick leave laws. But of course, those are the ones that result in someone from HR or someone in the legal department calling me and ask what can be done under Colorado's sick leave law. The misuse that we are typically seeing is that somebody is out on a vacation or perhaps out on leave and try to extend that leave or vacation by claiming that they are sick. And there's not a lot of things that employers can do under the Colorado law. I'm going to get to that when we get to our third point about doctor's notes. In Colorado, if an employee claims that they are sick, documentation is generally speaking not required, is not permitted to be requested. And so employers are, sometimes stuck with hearing somebody, calling from Mexico in the hotel room and claiming that they have a cough and then trying to extend their vacation by a couple of days. Again, I think that's the exception. I think most people in the workforce recognize that's not something you can do. But in terms of whether you have to grant somebody sick leave if they have, in fact, engaged in that sort of bad faith behavior, yes, you would be required to grant sick leave. That doesn't mean you can't have other types of disciplinary processes in place, particularly if the employee, you know that the employee has been dishonest. That's a whole separate can of worms that we can talk about separately. The other issue that we've seen quite frequently is particularly around the employers in Colorado who have elected to have unlimited PTO, or sometimes called flex leave policies. This is often for exempt employees who are not going to be assigned any particular number of days that they're going to have for vacation or sick leave. Colorado had a Supreme Court decision a few years back that said that all accrued unused sick leave has to be paid out on the last day of an employee's work. To avoid that, a number of employers have switched to these unlimited PTO and flex leave policies, and they've done it with our advice and our consent. We think it's a really good solution. But the issue here with this paid sick leave is now we have multiple buckets where employees can start deciding what time they're going to spend away from work. And we're starting to see a conflation of all those buckets. So sometimes you have people who are away from work because of reasonable accommodation for a disability. Sometimes it's going to be under FMLA leave, or as Ashley and Molly were just talking about, Colorado's version of paid sick leave, or it can be under PTO. And so what we're seeing a lot of is that employees sometimes will seek to extend their approved leaves by also then applying to either the sick leave or using the unlimited sick leave bank. Big piece of advice here is make your policies abundantly clear and make sure that you follow up on those policies to enforce them, that paid sick leave is not in lieu of or a supplement to any of these other buckets that are out there. There needs to be some definition, otherwise you're going to be driving your HR teams crazy in terms of trying to track it. And then the final issue, and it relates to both of them, frankly, is doctor's notes. Again, documentation is not required in the state of Colorado, but after 4 days, consecutive days, employers may ask for a doctor's note. I can't tell you the number of employers who do not have that 4-day limitation. A number of employers, sophisticated employers, employers who've had their policies reviewed by outside counsel, continue to have a 2 or a 3-day waiting notice period. I don't think I've ever encountered an employer that outside of the context of the mandatory requirement has had the 4-day limitation. So if you take away anything from this presentation on the doctor's notes, is remember, in Colorado, it's only after 4 days you can ask for the documentation of the note. So if you're dealing with the employee who's engaged in bad faith, trying to extend a vacation or something like that by using sick leave, keep in mind you can't just rely upon a doctor's note to be able to enforce that. That is prohibited under the policy, and you can't do that. Also, the documentation can't be specific. It can't be that the employer decides, for example, it requires the doctor to provide specific notification about whatever medical issue that the person is going through. Employees still have the privacy rights that are just in general that they have maintained. And this isn't like, say, reasonable accommodation where you can get a little bit more detail. So keep all these things in mind. It's a little bit difficult to navigate, but primary issue here is you can't ask for a doctor's note. And then think about how that issue is going to relate to what Maureen is about to talk about.
Thanks for that tee up, Chris.
I've got more if you need them.
Okay, all right. So another change that has actually already gone into effect starting August 7th of this year, where 2 new categories were added as paid sick leave. So the first we'll talk about are situations related to death of a family member. So the most obvious situations that come to mind are grieving or bereavement, attending services, but it also extends to supporting family members, the deceased family members in their financial or legal matters. And then the second situation that it extended to is in situations due to inclement weather, power, heat, or water loss, or other unexpected events where an employee has been forced to evacuate their residence or care for a family member whose school or place of care was closed due to similar events. And then very significantly, under the Healthy Families and Workplaces Act, the Colorado Department of Labor and Employment has always considered paid leave to be wages. And so this can lead to wage claims, either affected through a private cause of action or through a complaint through the Colorado Department of Labor and Employment. All of these are avoidable by taking the proper precautions to update notice to employees and to not limit those categories to those 5 previous, and to make sure they're inclusive of the new categories already into effect.
All right. So to the point that I was trying to make there before we move on to discrimination and harassment law, just keep in mind, if you're going to be asking for a doctor's note for a medical condition, that makes sense. If you're trying to ask for a doctor's note because somebody had their water out or their electricity out such they had to evacuate their home, that's going to be a little bit more unusual. And I don't exactly know how that's going to play out, but just keep in mind that because we've started now including under sick leave these categories that really don't relate to sickness, it's going to be a different issue in terms of how you're going to be able to document it, even if the individual is gone for in excess of 4 days. Okay, I started off the beginning of this talking about kind of like there have been some significant changes in particular areas of the law. One of the biggest ones, and one of the ones that was most hotly debated down at the state capitol, is sometimes called the Power Act, which is the Protecting Opportunities and Workers' Rights Act. This is a tag along to the issue of kind of the Me Too movement and making sure that there is full transparency and disclosure of employer misconduct. The law went into effect just a couple of months ago. And so now this is the Colorado law that we have. Again, for historical context, for years and years, any discrimination or harassment claims brought in Colorado were brought under federal law because federal law had compensatory and punitive damages. About 10 years ago, Colorado caught up. They provided compensatory and punitive damages. And so then there was the thought, for at least for some period of time, that federal law and Colorado mirror each other. That's not the case in Colorado anymore. Colorado law now provides more protections for employees in a lot of areas where multi-state employers in particular are going to be surprised. Okay, so the first issue that we're going to talk about is the severe or pervasive standard. For the lawyers in the room who took sexual harassment class, in law school, you'll remember this played an outsized role in our understanding of sexual harassment and how to deal with those issues. Okay, what the severe or pervasive standard was is that it wasn't going to be considered harassment unless it was objectively and subjectively severe and pervasive. So you could have severe, which meant that there was one instance that was truly awful, like an assault. Or you could have pervasive, where the entire workplace is riddled with discriminatory animus, bad jokes, discriminatory conduct, thing like that. But you had to meet a threshold before it actually became actionable conduct. I can remember taking my law school class, and I actually wrote a paper on this. And so this has been an issue that's kind of been percolating for about 25 years at a bare minimum. I can tell you now that's been removed from the state of Colorado, there is no threshold. Even minor incidents, including for current employees, could be actionable if it rises to that level. Now, minor incidents probably going to result in a lot less damages, but it still at least is actionable. What I will tell you, everyone on this call, particularly anyone who's ever done an investigation before, you have never once excused discriminatory or harassing behavior based upon whether it met the severe or pervasive conduct standard. What you have done is that if there has been bad behavior, it needs to be addressed. So in practicality, I don't think this is going to have a big deal in terms of the day-to-day operations of an HR department. It might have a slightly larger deal when you're dealing with perhaps a claim that's been filed by a current employee. Marina?
Thanks for that journey back to law school, Chris.
Do you want some more?
We'll see. So the next thing we want to make sure that employers are aware of is that Power also adds marital status as a protected classification. This is new in this context, but it actually just brings this as to be a more consistent standard. For example, marital status is already a protected classification under the Colorado Anti-Discrimination Act. So there is more just like a general trend here to include that as a protected classification. The next one is going to be changing the standard for employers who are considering hiring or are not able to hire a person with a disability. So it is not an unfair labor practice or discriminatory for an employer to not hire an employee with a disability if they cannot provide any reasonable accommodation that would allow that employee or potential employee to meet the essential qualifications of the job. That still is in effect. What is changing here is that previously that disability could only have a substantial impact on the job, but now that needs to be completely disqualify the employee from being able to actually perform the job entirely. So it's slightly higher standard for employers to be paying attention to. And then the last one, it just permits complaints through the CDLE or through the Colorado Civil Rights Division. And so that would be a similar standard, but just wanting to call that out here.
Okay, so let's talk about some of the big changes that we see. One is that there is an addition of affirmative defenses. The second is there's really a strong impact upon non-disclosure provisions in the various employment agreements that are out there. And the third one that I really want everyone to hear me say is that there's this new repository requirement. So let's go through each one of those. So the repository requirement, this is one that's caused me a lot of alarm just because I don't think very many employers are able to comply with it right now. I just don't think they are. Under the repository requirement under the Power Act, all Colorado employers are required to maintain records of all written or oral complaints of discriminatory or unfair employment practices, and they have to maintain them for 5 years. And so they have to do it either as after received or to the date of the final disposition. You have to include some very specific information. This is all in the statute. This isn't even in the regulations. In the statute, you have to have the date of the complaint, the identity of the complaining party, an alleged perpetrator, the substance of the complaint, and then you need to make sure that all these materials are going to be maintained for 5 years. There is 2 words that explains what this repository is all about. It's about punitive damages. The entire purpose of this version of the law that is now in effect for Colorado is that if you receive a claim from one employee, presumably there's going to be a request made for the production of complaints made about that about the individual who's alleged to have done the discriminatory act or the harassment. Perhaps there's going to be a discovery request where that even goes broader than that. I think that all of us who've litigated these claims are already anticipating there's going to be a lot of discovery fights about the production of the repository of 5 years of complaints. So if the employer is maintaining that repository for 5 years, understand it's going to be dangerous. It's going to be something that is going to absolutely be used by the plaintiff's bar when they're representing employees filing claims against you. The flip side of that same coin is the thing that also concerns me. If an employer is not maintaining an accurate repository, and it's a statutory requirement, what are going to the implications be if the employer didn't write down that a particular complaint was made? As we all know, if somebody reports in to an ethical hotline or to a designated individual like an ethics officer or a human resources professional, a lot of times those complaints are addressed adequately, even if they're orally done and they're not necessarily formally filed. What we also know, though, is that employees oftentimes don't make complaints that way. A lot of times employees will say that they don't want anyone to take any action on a complaint. They also sometimes will report their complaint to maybe a supervisor who hasn't necessarily been trained on the issue. So a piece of advice here would be make sure everyone in the organization who deals with this, particularly supervisors, but also HR professionals, legal, ethics officers, et cetera, all understand the requirement that this repository effect is in effect. The second part that we were talking about before is like, how does this going to impact, how does the Power Act impact types of employment agreements? Let's just remember when I'm talking about employment agreements, I'm not talking about just a formal executive employment agreement. I'm talking about like hiring, I'm talking about offer letters, separation agreements, confidentiality agreements, inventions and assignment agreements. The whole range of types of agreements are going to be impacted on this. Marianne, if you don't mind. Yep. And it's going to particularly impact those of us who do a lot of work in restrictive covenant space. So the restrictive covenants at issue are covenants not to compete, to solicit customers, non-disclosure agreements, and non-disparagement agreements. So under Colorado law, what we know is that, and by the way, there's an interplay here between the Power Act and the recent Colorado changes to the non-compete statute. I'm not going to spend a lot of time on this, but just a reminder, Colorado does restrict non-competes a little bit more than most states, not as far as California, which completely bans them, not as far as the FTC and the NLRB are proposing, but right now Colorado does restrict them, and they restrict them in this way. First, non-competes can only be applicable to employees who are highly compensated. That's a number that's set by formula. This year it's 112,000 per year. Next year it's going to be 123,000 per year, and that was calculated by my mathematician to the right of me here. Secondly, they need to be reasonably necessary to protect trade secrets. We don't have a management exception anymore under the state of Colorado. It must be for the protection of trade secrets. And third, it has to satisfy what I call the tripwire. The tripwire is you have to provide a separate notice to the employee, usually an executive, that they have in fact signed an executive agreement.
And so just one finer point on here for the non-solicitation of customer covenants, they do entail that same three-prong requirement, except the highly compensated threshold is only 60%. So for 2023, that is a little over $67,000. And then for 2024, that will be going up to a little over $74,000. And then those same additional requirements of they have to be reasonably necessary to protect against trade secrets, and they have to provide the special notice requirements have to be in effect as well. So what are those special notice requirements? Again, as a reminder, these have already been in effect since 2022. So if this is new to you, please let us know. But these non-solicitation and non-compete covenants, they have to be provided to the employees in a separate document. That document has to be identified by name. The section that that is pertaining to that has to be identified, has to require specific language, and then it also has to be signed by the employee.
And anytime you have a non-compete or a non-solicit that is in violation of these provisions, it is void. So that's the primary emphasis. But there's a special twist here that Marina is also going to talk about.
Not only are they going to be void, but then employees who have either been presented with these have the option to either bring a cause of action seeking actual damages or that $5,000 per worker harmed.
So how does that last provision impact employers? I'll tell you how it happens a lot in the outside counsel world. It's not at all unusual for our M&A counsel who when we're helping them out on a deal to say, why don't we just enter into employment agreements with non-competes that are going to be broad, 3 years for all the entirety of the United States or all of North America. And we always suggest to our counsel who are involved in those M&A transactions that that's perhaps not the best route to take because it's overly broad. And then what we usually get fed back with in terms of feedback is something along the lines of, well, let's make it as broad as we can. And that way employees won't be incentivized to go ahead and depart, taking our valuable trade secrets and working for a competitor. This provision about the $5,000 per worker harmed and actual damages, that is addressing that very issue because of the fear of the chilling effect. So keep in mind, in Colorado, there is a real risk to having overly enforceable non-competes. So a couple of other basic provisions are that you are still allowed to have non-competes to recover training and expenses. You absolutely still can maintain confidentiality agreements. So those mentioned assignment agreements that we kind of led this section off with, those are specifically called out and those are enforceable. I believe a decent reading of the statute is that these are even more enforceable than they were before. And third, and this is even the case in California, the purchase and sale of a business or assets also is sufficient to support a non-compete. So even outside of the context of something like a trade secret.
So bringing it back to the specifics of the POWER Act, the POWER Act makes it abundantly clear that employers should not be limiting employees' protected communications among themselves and among people outside of the workplace. So we have put big red letters here. Employers cannot be limiting employees from disclosing or discussing underlying facts from alleged discriminatory or unfair labor practice. And this is what we would really encourage, how we would encourage employers to be thinking about that. That does provide a permissive standard that if employers really do want to include this, that they must include adequate disclosures. And so these are going to be popping up in instances of offer letters, of severance agreements, of separation agreements, and then all of the provisions that Chris has already talked about. So if employers are really set on including these, then they must use specific language. They must include disclosures where applicable. it must specifically not apply to those underlying facts from alleged discriminatory or unfair labor practice, and they must apply equally to all parties. So an example here that's provided in the Act is that, say, for instance, an employer has required an employee to agree to a non-disparagement clause in an agreement. If the employer then turns around and disparages the employee, they will then be precluded from being able to enforce that against the employee themselves if they chose to do so. So again, we would really encourage employers to not be limiting this kind of employee communication, but if you choose to do so, take very specific precautions because this can be what Chris has been calling a poison pill for you all to be mindful of.
Yeah. So much easier to exclude that. So keep in mind that if you have any violations of this specific provision with respect to non-disparagement provisions that might relate to underlying acts of discrimination, that also results in a separate cause of action, actual damages, $5,000 per violation. And keep in mind, this would be the sort of behavior that might lend itself to a class action type of an allegation. Not necessarily willing to concede that a class action could be formed around this, but it certainly is a possibility. So then on top of that, there's also some penalties associated with it.
Well, Chris, that brings us to the end of our presentation. Thanks so much for joining us today. Thanks for the conversation, to the extent it was a conversation.
I was required to do it, just to be clear.
And we look forward to seeing everyone on the next round.
Thank you, Chris and Marina. That was a lot of information jam-packed in a short amount of time, but hopefully all of you walk away with a lot more knowledge of all of the updates in Colorado, and I know there are many of them. So we're ready for our next poll question, and it's up on your screen. The question is, do you think that if your employee is exempt under the FLSA, the Fair Labor Standards Act, then they are also exempt under Colorado law? So please indicate if you think the answer is yes, no, or unsure. I'll give it another little bit for everybody to get their answer in before we pull up the results. We're at 50% of you responded, so thank you for that. Okay, here are the results. 15% of you think the answer is yes, 61% think the answer is no, and understandably, 23% of you aren't sure. So with that segue, I'm going to let Barb and Keith talk about unique wage and hour laws, and they're going to address this specific question and explain how the FLSA intertwines with Colorado wage and hour law. So as many of you know, Barb is a partner in our group in the Denver office of Husch Blackwell, and Keith Ibanez is an associate in our group as well. And they're going to go ahead and start the third presentation. Take it away.
Thank you, Ashley. The poll results are interesting. That'll be a specific topic that we discuss later, but 15% of people thinking that if they're exempt, if they have employees who are exempt under the federal law, they're also exempt under the state law. I think those 15% at least are going to be surprised by some of the stuff that we talk about a little bit later on. California, or Colorado, I like to refer to as California of the East, although I've been reminded that although Colorado is not in the East, it's still east of California. But we are every year facing more and more laws being passed in Colorado, regulations that make it harder for companies to do business. And wage and hour is one of the areas where Colorado does differ from other states and from the feds. And so our goal today is to cover some of the new changes in Colorado with you, but also to point out some of the things that have been around for quite a while that we want to make sure you're conscious of as being different in Colorado than elsewhere.
Thanks for that, Barb. And to be clear, I am the geography region enforcer of our office, so I appreciate that acknowledgement from you. All right, so I'm going to touch on the Colorado Overtime and Minimum Pay Standards Order number 39. This is not yet enacted or enforced. This is still a proposed rule, but for all intents and purposes, we are operating under the assumption that the Order number 39 will be adopted as it's currently written. And the comps orders are important to look at and to understand because they're the key source of all the rules and regulations for Colorado's wage and hour laws. So it's important to see what's been changed, what's been added, and to stay on top of those things. Now, comps number 39 has some new revised definitions. The first one we're going to look at is time worked. And to be clear, this is not new and it's not a change in any definition, but they did want to rework, and by they, when I reference they or the division, I'm talking about the Colorado Department of Labor and Employment's Division of Labor Standards and Statistics. So that's who I'm referring to. You can direct all your complaints to them, not to me. So the time work definition has been revised just to indicate that pre and post shift activities that are otherwise excluded under compensable time or time worked under the Federal Portal to Portal Act are still recognized as compensable time that is time worked under Colorado law. However, there is that 1 minute threshold within the definition that seemed to be a point of confusion since it was first introduced in comps number 36 in 2020. So the division in its wisdom sought to clarify its position that time worked means these activities, so some of these activities are in the bullet points for you there. They may not be core principal tasks for an employee, but generally come before their shift or their first principal act of work or afterwards. And so the division wants to make clear this is not a narrowing of what is time worked. They still recognize these activities as time worked so long as cumulatively they take over 1 minute and they're otherwise excluded by the Portal to Portal Act. And I think this was an interesting or notable clarification just because this could have been an opportunity for the division to pivot or to shift its position, but they want to make clear that while federal law says this, we're not following that. And that leads us to our next topic that I wanted to just bring to our audience's attention is rounding. Now, federal regulations permit neutral rounding policies, which are policies that will not result over a period of time in any failure to compensate employees properly for their time worked. Employers can take different approaches to the rounding policies. It can be to 1/10 of an hour, 1/4 an hour, but it's permissible under federal law. California used to follow that federal law procedure in permitting neutral rounding policies, but its courts, in its courts of appeal, have reversed course in the last year. There's now a case pending in front of the California Supreme Court. It's the Camp versus Home Depot case that looks poised to eliminate the lawfulness of neutral rounding policies in California. And since, as Barb alluded to earlier, Colorado seems to be trending towards the California of the East/Mountain West. It's something I wanted to bring to our audience's attention because it's something that bears monitoring. Now, Colorado currently does not take an express position on rounding, other than saying that the practice can't result in the employees being paid less than minimum wage or their agreed upon rate of pay, which seems to be an acknowledgement that neutral rounding is permissible so long as neither of those two ideas or policies are violated. So it's just something to bear watching over these next few months and year in case our CDLE or the division takes a more rigorous approach to rounding policies. The next one is tipped employees. Now, I have a lot of opinions about tipping practices. They seem to have changed drastically in the last 5 years. I will not force you all to listen to them, but if any of you have strong opinions about them, feel free to give me a call and we can talk about them. But this definition's been revised as well in a couple ways. First, the definition of regular rate of pay was revised to exclude expressly that tips are not included in the calculation for an employee's regular rate of pay. That's an important distinction that follows federal law, which also expressly excluded tips from an employee's calculation of regular rate of pay because it affects what the employee may earn in their overtime rate. Colorado previously, before this Comp 39 proposal, didn't say one way or the other whether tips were included or excluded, which, as you can imagine, resulted in lots of questions to the division. So I think they got tired of answering those questions, and now it is expressly excluded. And then the tipped employee definition has also been changed. Its current iteration defines tipped employees to be employees who regularly and customarily earn $30 per month in tips. It's an old definition. The $30 threshold is one that was first established, I believe, in 1977, when $30 was a much more significant sum than it is today. So this proved to be problematic in a lot of different ways in our current culture of tipping. It doesn't take a lot for an employee to receive $30 worth of tips in a month, but the monthly definition was an interesting demarcation because it didn't quite work for part-time and full-time employees. So that definition has been changed to $1.55 per hour, which I think is much more adaptable to employees that have varying hours or schedules or roles. And I think the $1.55 amount also acknowledges that the $30 a month threshold in 1977, if we're extrapolating that out for inflation to today, 46 years later, I think comes out to about $184 a month. So that is a calculation that's based off of an employee working about 30 hours a week. But if they don't reach that full-time position, or they're not in a role where they're working that much, the $1.55 per hour figure still makes sense for those part-time employees. And then the definition also changes which employees can be eligible for tipping pools. Now, this is significant also because obviously employers in Colorado may apply a reduced minimum wage rate for tipped employees. The customary definition or word in the definition made this a little more confusing over the last few years as tipping practices have changed. The traditional roles that get tipped directly from customers, like wait staff, housekeepers, and such, that is expanded, but the definition of customary obviously does not generally keep up with those changes in our society. So that's been changed. Customary has been removed, and now the definition includes regularly receives tips, and for the tipping pool eligibility, and thus the minimum wage tip credit, the definition's been adjusted to apply to employees who perform significant customer service functions in contact with patrons. So it's a much more duty-focused definition rather than just arbitrary or confusing discussions about who customarily and regularly receives tips. So that's an important one to know. That may change some of your planning, your business planning and budgeting planning if you previously tipped employees may not work under this new definition.
So Keith, I have to say kudos on the complicated math there. Nice job.
Thank you. Some lawyers can do math.
Excellent. And then I just wanted to ask a question. I was thinking back to the 1 minute compensable time issue. I can't really think of anything that would take less than a minute on that list.
Yeah,
and can you?
That's a good distinction. So yeah, individually, each of those items will probably only take a few seconds or maybe close to a minute, but it's cumulatively, do they take over a minute? So if you have multiple things on those, multiple items on that list to do, you can take off your uniform, put on, check in about your assignments or check out about work you've completed that day or clock in or out. If all of that cumulatively takes over a minute, then you're passing that threshold and that's time worked. Now, if you're only doing one and it is less than a minute, then that time will not be time worked under the definition.
Yeah, I can only imagine the proof issues that brings up if you ever end up in court.
Exactly.
Yeah.
Sit out there with your stopwatch and start timing your employees. That's the implication.
Yeah, great.
And then just quickly, this may not be applicable to many of you, but there is a new overtime exemption group under Comps 39. It's a narrow class, really just applies to airline or air freight or air route workers who exchange or swap shifts with other colleagues, and that shift swapping practice takes them over the overtime threshold. So that when they're voluntarily doing that, overtime does not need to be paid for that time. Right. And then quickly, our wage complaint and investigation process in Colorado is a little different. So there's a timing mechanism here that is specific to Colorado and not generally applicable under federal law. And that's when an employer receives a wage demand, they have 14 days to either pay the outstanding wages or provide a response to the employee explaining why those wages are not owed. If they don't pay within the 14-day time period, then penalties will kick in. Now, the penalties can be much more onerous than the FLSA allows. If the penalty is for a willful violation, then it can be 4 times what the amount of outstanding wages are, or $3,000, whichever is greater. The federal penalty is much less, at like about $1,000, up to $1,000 per penalty. So it's not something you want to get wrong. So just be aware that our penalties in Colorado are much more severe. When you get a wage demand for an employee, the clock starts. So make sure that doesn't sit there on someone's desk for a while. Make sure you address it or pay it as quickly as you can. And another interesting area is local minimum wages. So we have our state minimum wage, which in 2024 is $14.42, just about double the federal amount at $7.25. But then Denver and the city of Edgewater also have their own local minimum wages, which are higher than the state amounts. This is something to be aware of with remote employees working at their homes for the majority of the week. The local minimum wage kicks in once an employee has worked for 4 hours within that local jurisdiction in a week. So if you have a remote employee, they work at home twice a day in Denver. If they're paid at the minimum wage, then their minimum wage is going to be at $18.29 and not the state's rate at $14.42 for that time worked in Denver, not all their time. Right. So that's something you have to keep track of. Likewise for Edgewater. But the Colorado Constitution still allows for you to apply the tip offset of 302. So that's something that will apply to those local minimum wages. But those are still pretty high figures, so just be aware. Quickly before I move on from that, for employees that are passing through a jurisdiction with a local minimum wage, important to know that if they're just driving through and they're not actually stopping to do work in that jurisdiction, that time is not applicable to that local jurisdiction's minimum wage. So if you have drivers who are passing through those jurisdictions often but not working in them, then you need not worry about the local minimum wage. All right. And then lastly, our highly compensated employees threshold and definition is a little different in Colorado than the federal standard. So our amount in Colorado moves up to $123,750 in 2024. And there are a few differences within how the HCEs are treated under Colorado law. The FLSA allows for a catch-up provision, meaning if an employee receives a end-of-year bonus or some other award of wages in the beginning of the following year, that amount can be attributed to their say 2023 versus 2024 salary to make them eligible as a highly compensated employee who's not otherwise eligible for overtime. Under the federal law, employers only have till the next payroll period to make that catch-up payment, whereas under Colorado rule, it is 1 month. And then likewise, I think I saw a question in our Q&A, and I knew I was going to address it here, so I saved an answer. But bonuses that are guaranteed and not discretionary can be applied to an employee's HCE threshold, and non-discretionary bonuses can also be applied, as well as commissions. But we don't have the cap that the FLSA does of 10% of the employee's salary. So a large bonus that can take an employee from $90,000 a year in annual salary to $130,000 a year in salary will make them eligible as a highly compensated employee in Colorado, even though that bonus is disproportionately larger or makes up a disproportionately larger amount of their salary.
Great. Thank you, Keith. And I'm going to pick up on a few of the additional exemption issues. So Keith just gave you an example where having a highly compensated exempt employee in Colorado is actually easier than it is under the federal law. I'm going to point out some examples where if you are not meeting the duties test or the salary threshold under Colorado law, doesn't matter if you meet it under the federal law, you cannot treat that person as overtime exempt in Colorado. So the first way that we have that difference is that Colorado has a different salary threshold than the federal government. So as a reminder, in order to be an exempt employee, generally, you have to be paid on a salary basis, the same amount every week, regardless of how much you work. And you have to be paid a salary at a certain threshold. Under federal law, that threshold is still $55,000 a year. The government has tried to change that many times. It usually happens with the change of an administration. As recently as August of 2023, the feds have said they want to raise the federal salary threshold, and we'll see if it works. Colorado, though, is actually raising that threshold. And so for 2024, somebody in Colorado is going to be making, I can't see my slide from that far. Colorado, the threshold is $55,000, and I misspoke. The federal threshold is currently $35,000. So you cannot have an exempt employee in Colorado unless they're making at least $55,000 a year. And that number is going to go up every year. The federal proposal is to bring that 35 in line with the 55 that Colorado has passed. Additionally, highly technical computer employees can also be considered to be exempt if they receive a certain wage rate. And in Colorado, that is $33.17 an hour as compared to the federal rate of $27.63 an hour. So in addition to the salary threshold that's higher in Colorado and harder to meet, there's also a duties test that has to be satisfied for someone to be considered to be an overtime exempt employee. And Colorado has some duties tests that are actually different than the federal. So you could have a situation where somebody makes the Colorado salary threshold, but they don't meet the Colorado duties test for the exemption. Therefore, you cannot treat them as an exempt employee in Colorado. And a good example of this is what you would call the supervisor exemption or the executive supervisor exemption. So under the federal duties test and the state duties test, there's a supervisory component. You're supervising 2 or more full-time employees. You have the authority to hire and fire, or your opinion is given particular weight in that decision. That's generally the same under both state and federal law. However, under federal law, you have to establish that the person's primary, their most important major principal duty is something that involves managing the organization or a department. And so the primary most important duty is what matters under the federal test. Colorado has reduced it very much to a mathematical formula. And in Colorado, you have to spend at least 50% of your time in these supervisory duties. So you could have a situation where somebody's most important duty, their primary duty under federal law, is something that they spend less than 50% of their time doing. And under Colorado state law, they would not qualify for this particular exemption. The next thing I want to cover is the Equal Pay for Equal Work Act that Colorado passed in 2021. To add complication to it, this year, Colorado has amended that, and we now have the Ensuring Equal Pay for Equal Work Act. So the acronyms just keep getting longer. But as a result,
other than to make the acronym longer, why are we revising this just 2 years later?
Thank you. It's the acronym issue, I think. And then frankly, I think that the amendments are coming. There's been a lot of activity in the pay transparency portions of the law. And I think that there has been a recognition that some of those pay transparency rules have been more complicated than they should be for employers to follow. And so this, I believe, is an effort to clean those up and provide some clarity. So on a positive note, as you can see from this slide, according to Indeed, more than 50% of US-based job listings now contain salary information. So that's a 10% increase from 2019. So Colorado was a leader on this, and there are a number of states that are now following, and it appears to be something that's going to be the norm across the country. The changes that have been made in an effort to clarify, the first one is that we were previously dealing with something that was called a promotional opportunity. And I think that was confusing for employers to try to understand what a promotional opportunity really meant. And so now with the amendment and the proposed revised rules, we aren't talking about promotional opportunities anymore. Instead, we are talking about something that's called a job opportunity. And a job opportunity is something where you have a vacancy in a position. It's either a newly created position or you have a vacancy in an existing position. You are considering a candidate or candidates, and you are interviewing a candidate or candidates, or you have externally posted the position. So the rule is if you have a job opportunity, you're posting it. We also have exceptions to the rule, and this is another effort to clarify. You do not have to post, because the term job opportunity specifically now excludes two things. One is called career development, and the other is called career progression. A career progression is something that was already alluded to and covered originally in the Act. That is somebody who has moving from accountant level 1 to accountant level 2 because they've accomplished the skill set of an accountant level 1. They're progressing in their career. And now the career progression does not have to be posted. The new one is this career development. And a career development is a position that somebody's being moved into that is not otherwise a vacancy. And it's a change that is reflecting contributions that have already been made by that employee. And those contributions or the work that's being provided is already part of the employee's existing job. So an example of this that I could envision is somebody in the Human Resources Department who has responsibility over benefits. You're now going to change that benefits role to be a manager or a director role. And the person that's getting that career development opportunity is the person that's been handling your benefits at the lower level, who's now being promoted based on their existing work and job duties into this new benefits manager position.
That sounds like a common sense change.
We'll see. We'll see. There's also some revised content rules for posting. The new statute and rules make it clear that whenever they use the words posting or notice, they mean the same thing. So if that's been a mystery, it's been resolved. You're still going to post the hourly rate or salary, a general description of any other compensation, a general description of benefits. So that's all the same. Now you also have to post or provide notice of the application window when it closes. And if it's an evergreen application, you're always hiring servers, then you need to make that clear as well. And you have to tell people how they can apply for the job opportunity, which you probably already do when you're posting. On the window, if you decide to leave the job open a little bit longer or make a change like that, as long as the window that you posted was originally in good faith and you update the posting with the new closing date for the window, you'll be okay as the statute and rules have been amended. There's also a new requirement of some more notice that you have to give. And this one really baffles me. I don't know, Keith, if you've thought this through, but you now also have to provide a post-selection notice. So once you have filled the position, you have to tell everybody who that person regularly works with, who's been hired to fill the role. And I feel like the people they regularly work with would already know who's filling the role. Yeah.
It's a strange one and doesn't make a lot of sense. I guess it's like not harmful, but it's just a weird place to make employers trip up for some reason.
Yep, just another hoop that you have to jump through. And the content of the post-selection notice is mentioned here on the slide. It's not really anything that you would do differently than a general welcome to the company notice that you're sending out probably already. You must send it to the individuals that who regularly work with the new hire or the person that's been promoted, but you can certainly send it more widely if you choose to do so. And then after you've listened to me for the last 10 minutes or so, we have good news for the out-of-state employers that got caught up in this pay transparency posting law. There's now a safe harbor until July 1st of 2029. And if you have only remote employees in Colorado, which means you're not a Colorado-based employer, you have only remote employees, and as long as you have fewer than 15 employees, you don't have to comply with these pay transparency posting and notice obligations. So congratulations on that. You are still covered, though, by the Ensuring Equal Pay for Equal Work Act, and in particular, the equal pay provisions of that we're still waiting to see the case law develop. Finally, then, because this presentation, I think, could go on for a really long time, I just wanted to share this reminder slide of a number of other things that we have that are unique to Colorado that could easily trip up even Colorado lawyers, but certainly out-of-state employers and employers that have a remote employee in Colorado that they might not even realize. Those things include Colorado has a daily overtime provision, people who work more than 12 hours in a day, and people who work more than 40 hours in a week get paid overtime. We have some pretty strict and unusual meal and rest period rules, very similar to what you might find in California. We've got sleep time rules. We've got rules that relate to specific industries, and agriculture is a big one that has been added recently. We've got rules about uniforms and who pays for them and how you handle compensation associated with that. We've got posting requirements and notice requirements that relate to our wage and hour order that applies to all the employers. And then we also have vacation and PTO payout rules. This is not a state where you can say you're going to accrue a certain amount of vacation, but if you leave, it doesn't have a cash value. Colorado says once it's earned, you can't take it away. And so that, I think, is also something that's unique to Colorado and a few other states, but it's not intuitive to all employers across the spectrum. And with that, I will turn it back over to Ashley for our next poll question.
Thank you, Barb and Keith. That was a lot of information on Colorado's wage and hour regulations, and I know they're always changing, so we really appreciate the update, and hopefully all of you on the webinar found it very useful. So want to move on to our next poll question. This poll question will tie into our final presentation of the day concerning artificial intelligence. So the poll question is, has your place of work implemented any AI apps? So yes, frequently, yes, somewhat, no, but we want to or plan to, and no, we don't want to have anything to do with it. So I'll give everybody a chance to answer that poll question, and then I'll let you know what the results are. All right, can I get the results? Okay, we had several hundred of you respond, so thank you for that. Okay, so only 3% responded, yes, we use them frequently. 30% are at yes, somewhat. 26% are at no, but we plan to. And then the majority of you, if there is a majority, said no, we have no plans to do that. That was at 39%. So that ties into our final presentation on AI. So we have Senior Associate Shauna Ritz of our group and Owen Davis, associate in our group. Both of them are in the Denver office of our firm. And again, this is our final presentation. So I'm going to send it over to the two of them.
Thanks, Ashley. So yes, let's see here's the title page. So yeah, we're here today to talk about artificial intelligence. It's sort of an amorphous topic that has been getting obviously a lot of attention this past year. And we've been working with a lot of clients who are, looking for ways to implement AI or are already implementing AI in their offices. The other consideration too is that some employers might not have any intention to do so, but their employees are using these tools already. So because this is a quick, developing, evolving topic, this is sort of a level set to talk about kind of things that you should keep in mind as this technology grows in popularity and develops further and new capabilities. So we're going to start with just kind of generally talking about what is AI in the context of employment. We're going to then talk about the inherent risks involved with using AI tools, the current and future legal landscape, regulatory landscape for AI, and then also some considerations for putting together an AI policy in your workplace. So to start with, what is AI? Again, this is it's an amorphous subject. There are different types and models of AI. Generative AI is currently, at the forefront of everyone's mind, like ChatGPT, for instance. And that's honestly, that is the type of tool that we're seeing in a lot of workplaces grow in use. Now, to start here, these are some legal definitions of AI. Now, again, there just aren't that many laws on this subject yet. So I foresee these legal definitions changing in the near future as new regulations and statutes come out on the topic. The key thing I want to bring your attention to is that it's a computational process that influences, assists, or replaces discretionary decision making by a human. That's what the laws that apply to AI in the context of workplaces are really focused on. And so there can be wiggle room, right? If you're using AI tools for certain automated tasks, that might be something subject to one statute compared to using an AI tool to help assist employers in making certain decisions. And kind of for fun, the last bullet there is a quote unquote legal definition that I asked an AI chatbot to generate. And I don't find it very helpful. I think it's pretty vague, somewhat abstract. So I think it goes to show that, I don't think AI chatbots will be writing our laws anytime soon. And at least I really hope that's the case. So let's briefly talk about the recent history of AI. So it's really that 2022 bullet. OpenAI released ChatGPT, GPT 3.5, based on 3.5. That's kind of when it seems like the world exploded and could talk about nothing but artificial intelligence. But one thing to keep in mind here is that, the concept of AI has existed since the 1950s. Think of Alan Turing. The first chatbot was invented or came out in 1966. So there's been this long runway of development with these tools. And it's only very recently that these tools have come out in a way that can be widely used by the public. They're what are often referred to as fundamental models, where it's basically it's an AI model that can be used for several different tasks, or thousands, millions of different tasks. It's not designed to execute a specific task, and it's based off of unsupervised training of unorganized data. So it's just, again, it's very amorphous. It's hard to explain what goes into an AI model and why, and explaining what comes out of it. So again, generative AI is what most people think about today in this space. We have chat bots. I've even, I recently listened to a podcast that talked about AI being used in Hollywood movies to like de-age actors. It's really something. What I want you to take away from this list is that this is a technology that is infringing on all spaces in our daily lives. And whether or not you want to take advantage of it, use it, implement it in your office, it's coming. It is going to start impacting day-to-day work, whether you like it to or not. And you can see that specifically in something like Copilot. This is Microsoft's AI tool that's going to be rolling out to Office 365 applications very soon. This is going to be something that's just very easily accessible in applications we're already using on a daily basis. Co-Counsel is the fun example with Co-Counsel is that this is an application that passed the bar not once but twice, and I think the second time it got a higher score. So these are just some of the popular programs that you might see news about. I'll pass it on to Shauna.
So this is an example of what an AI imagery tool can do. It was asked to produce an image of a white German Shepherd intent on getting his puppuccino. And you can see from the image, it created what looks like a Starbucks with soft lighting in the background, coffee cups in front of the dog. It was able to infer from the word puppuccino how to create a scene that looks like a coffee house. And this is another example of what you can do with AI. So this was a dense article where three pictures were taken of a dense article, and the AI tool was asked to summarize what was in the materials. And it was able to create just a few bullet points outlining the article. One example in here of what it could pick up on is the article was discussing different artists, including The Weeknd, and it spelled The Weeknd correctly without the E at the end of it. So it was able to understand the concepts that were in the pictures that were taken. And so this is just a quick quote that AI won't take your job. It's someone using AI that will. I think that's one of the big concerns we've heard about is, how is AI going to impact people in the workplace? And we're really seeing employers trying to embrace AI, figuring out how they can use it to make their workers more efficient, and not being scared of kind of this unknown and new technology that we're experiencing. So next, we're going to talk about risk. So inherent risk with AI, the first one is bias. So AI is trained using historical data. It can use information that has already inadvertently been biased, and then it processes that information and will output potentially biased information. So an example of this would be an AI system that's used for hiring and recruiting. And it's based on data of successful applicants who are predominantly a certain gender or ethnicity. When it's then screening for candidates, there's the potential that it can screen for unprotected classes based on the information that had been input into it. We'll talk about this a little bit more. The EEOC has rolled out guidance on these issues, which Owen will talk about later on. The next inherent risk is confidentiality. So when using AI, especially in the workplace, you need to consider the AI tool that you're using and what the guidelines for the AI tool are, whether or not the information that you put in will be protected or not. General AI tools will not provide confidentiality, meaning if you put your confidential information in, it could then be used to generate information for someone else's request. Developers and those behind the scenes using the AI tool will be able to access your information. So you want to keep that in mind. You want to make sure you're understanding the AI program that you're using and setting up any kind of security or guidelines around it. Copyright is another big issue, and so this kind of falls into copyright, trade secrets, and patents. So copyrights protect original works of authorship, such as literary, musical,
dramatic works, motion pictures. So AI is trained on a large data set, and it will generate pictures and those kind of works from information that has been input into it. So if you're generating pictures or other works, you need to be careful whether or not AI is infringing on copyrighted material. For trade secrets are information that a company makes reasonable efforts to keep protected because it provides an economic value to them. Companies are expected to safeguard their trade secrets if they want to have protections of trade secrets. And so if employees are using business information that's considered trade secrets and putting that into an AI, again, it could become output for someone else's AI request, and then also raises the issue of, is it truly a trade secret if it's not being kept confidential and being protected? So due diligence is something that you're going to want to keep in mind. AI data is only as good as the data that it's pulling from. So an example of this would be, and this kind of goes to bias as well, is the example of asking AI to produce a picture of what a good doctor looks like. And AI, based on the information that's been fed to it, would spit out a picture of white males. So, you know, if you're using this in the workplace, you have an obligation to do your due diligence, check the information that's being output, and then be transparent about it. So one of the things that we recommend, and we'll talk about when we get into workplace policies, is disclosing on documents that you are using AI, being transparent on were they quality checked, how and when were they quality checked. And so that's a way to ensure that you're reviewing AI information and doing your due diligence to make sure that it is accurate and correct. You'll want to keep in mind the difference between correlation and causation. So causation is when one event causes another event. AI at this point is mostly pulling based on correlation. So they are related, but not necessarily causal. And so that's something to keep in mind as you're looking at your AI results. And then over-reliance. So again, you want to make sure you're checking anything that is coming out of AI. AI has been known to produce what are called hallucinations. So information that looks like it's correct, but is not correct. So an example of that we've seen is asking AI to produce websites on a specific topic based on documents that's been provided. AI can create and make up websites that if you look at them, you would think they look like correct websites, but in fact, they're false and completely made up. So you'll really want to be double checking and not overly relying on AI information. So intentional risks. There's different kind of intentional risks that you may have heard of. The deep fake is one of the most heard of right now, which could be either false videos, pictures, or using someone else's voice. And so AI can, for example, take a 10-second recording of someone's voice and duplicate it. So you can think of how that can be used for different kind of scams, such as calling someone and asking for money, but using a voice that sounds like someone else's that's been recorded from a voicemail message or from a video online. And so that's something to be aware of. AI enhanced malware. So there's the potential for this. Right now, there isn't any proven AI malware, but what people are concerned about is that AI will learn how to target individuals. So right now, for example, there may be a scam where a large group of people are targeted, knowing that a small amount will fall for the scam. AI enhanced malware would learn as part of the scam and be able to customize its responses and answers to questions to narrowly target all individuals. So that's something of concern. Social engineering is, again, manipulating, influencing, and deceiving people in order to gain control over their computers. So this could be phishing schemes, anything like that, where AI is used to gain access to information. And then synthetic media is media that's created by AI. So just all things to be aware of how AI can be used for not good reasons. Thanks. I'll turn it back over to Owen.
Thanks, Shauna. So I'll just add to those risks that Shauna talked about. Some of these tools can be built to sort of be closed systems. So information that you're putting in is not necessarily going out to the internet, to the entire public. That said, there's still the same confidentiality and trade secret concerns. There's also the concern about what information is being retained from, I'm thinking specifically like a chatbot application, the prompts that are sent to it, are those retained? Are those accessible? Are those discoverable during litigation, for example? So these are just all the different things that you kind of have to think about as you process this. So given these risks and the unanswerable questions that are currently out there, how is this technology being regulated? Now, obviously, this is sort of a new frontier for labor and employment law. So what I'm going to do in this section is kind of give you a basic rundown of what some things that currently exist, but I really want you to think more about general themes from these laws and the guidance that I'll talk about to kind of predict what future regulation will look like in this space, because undoubtedly this regulation will be coming. So first, I'll mention Illinois. A couple years ago, they passed this AI Video Interview Act, and it regulates an employer's use of an artificial intelligence tool when interviewing, or uses an AI tool to analyze a video interview of an applicant for an Illinois position. So this is kind of the first real law that we've seen on the books to regulate an employer's use of AI. The act requires you to provide notice to the applicant. You also have to explain to the applicant how the AI tool works. And that's, for example, describing to them, what characteristics the AI tool will be analyzing and assessing. And then there's also a consent requirement before using the tool. There's also a privacy aspect to this where employers are required to delete any recorded video interview that they have of an applicant if the applicant requests them to do so. And finally, the law was amended in 2021 to add a requirement for employers that only use AI tools to assess whether or not to do a follow-up in-person interview. Those employers are required to collect selection rate data resulting from use of the tool and reporting that data to a state agency. So that's where you see sort of like a testing component coming into these types of laws. Next, we'll go to Title VII. So the EEOC this year released some guidance about employers using AI in selection procedures. This is a sort of a follow-up guidance to what the EEOC issued last year about the ADA and issues that arise when you're using AI tools that could potentially discriminate against those with disabilities. But this guidance focuses on Title VII, and it specifically focuses on disparate impact, relying on guidance from the 1970s about selection procedures. The EEOC is very clear in saying that an employer can be liable under Title VII if it uses an AI tool in selection procedures that results in disparate impacts on protected groups. And that is even, the EEOC is also clear to say that that's even the case if the employer did not develop or is not administering the tool themselves. So that's really important to keep in mind. So as some general guidance, the EEOC is saying, monitor your selection rates, make sure that the developers of the tools have assessed their own selection rates, have done their own assessment to make sure there's not any disparate impact. Second, if there is a disparate impact, correct it immediately, find mitigating alternatives if and where possible. And then finally, while the EEOC says to make sure that these developers are doing their own assessments of selection rates, don't trust them. Do your own assessments of selection rates. Make sure that that the use of the tool is not resulting in a disparate impact. All right, so next, New York City. This is probably the most high-profile law from this year that specifically regulates in this space. So this is Local Law 144, and it applies to automated employment decision tools used by employers, specifically within the context of making hiring and promotion decisions. And so this applies to employers located in New York City. It applies to employees located in New York City. And it also applies to remote employees who are, quote unquote, associated with New York City. There's obviously a little ambiguity with that. So only time will tell exactly how this law will be applied and enforced. But that's something to keep in mind. So again, with this one, you see the transparency element of you're required to give notice. You're also required to provide notice on your on the employer's website. The major part of this law, though, is this independent bias audit that you have to run for the tool that you are using to monitor, again, selection rates, making sure there aren't disparate impacts. This is an audit that examines race and ethnicity, impact ratios across sex, and intersectional categories as well. Importantly, this audit has to be done by an independent third party. It cannot be done by the employer themselves, and it also cannot be done by the developer that created the tool that you might be using. Importantly here too is that employers are required to publish the results of their audit on their website. So again, that's another transparency aspect. All right. Finally, I'm going to just briefly talk about the California Consumer Privacy Act. So this is a law that has been around for some time, regulating mostly consumer privacy. But starting this year, the act began applying to employee data, so personal information that employers collect from California, from their employees who are California residents. Now, an important caveat is that there is a revenue threshold, there are a few different thresholds in determining whether the act applies to your business or not. There's a $25 million revenue threshold. There are also thresholds that depend on how much personal information you're processing each year. But if the act is applying to you, there are a lot of robust disclosure requirements. You're required to publish a very comprehensive employee privacy policy that talks about how you collect and use the personal information of your employees. And then employers are required to set up a process for responding and complying with employee privacy requests. So employee privacy requests are basically ways that they exercise their privacy rights under California law. So that includes like the right to delete, the right to correct. So you need a system in place. If the law applies to you, you need a system in place for fielding those requests. So while the law doesn't specifically say anything about artificial intelligence in the employment context, there are clearly implications. So the most obvious one is, what personal information of employees are going into these AI systems that you might be using. And to the extent that this is happening, if personal information is going into these AI tools and then being shared with an outside party, if that's the way that the tool works, then that's something you need to disclose to employees. There's also a requirement that you create a data process, or you enter into data processing agreements with any outside third parties that personal information is being shared with. So these are just all the different things that you kind of have to think about when and if you're implementing these tools in the workplace. So kind of looking ahead, at the regulatory landscape, you know, kind of the main themes that I pick up on from what I've just talked about are sort of first, transparency, you know, the notice requirements, publishing audit results on an employer's website under New York City law. Next is privacy. You see that in the Illinois law that I talked about with the deletion, the requirement that you comply with deletion requests. And then finally, testing, which is most obviously seen in the independent bias audit under New York City law. So I kind of foresee, you know, any new regulation that comes out, which will be coming, is going to have one or all three of those components as a part of it. The list of states you see there, beginning with California, those are all states that have in recent years considered bills that regulate the use of AI in employment. So I think it's worth keeping an eye on those. Colorado, Governor Polis has created this commission called the Office of the Future of Work. And one thing that they are specifically looking into is AI in the workplace. So it'll be interesting to see what comes from that. And then finally, I just want to mention, you might have seen that President Biden issued an executive order just this Monday. It's a very comprehensive kind of list of goals and initiatives to sort of frame the use of AI in the United States by creating sort of an interagency framework to create regulations, but also find ways to support kind of the adoption of AI in the United States. And for our purposes here, one of the requirements of the executive order is for the Secretary of Labor to draft and issue a report to the White House that identifies areas where spaces where AI can be regulated in the workplace and how it can be better adopted for employers. There's also a requirement that the Secretary of Labor in the report create disclosures for federal contractors that might be using AI. So again, this is a changing field. It'll be interesting to see what happens there. And then lastly, I just want to mention this one case, Mobley v. Workday, Inc. This is a currently pending class action in California, where the plaintiff is alleging that Workday had created this artificial intelligence tool, the system that other employers had adopted to screen candidates for different positions, and he's claiming that it was discriminatory. And I think he alleges that he applied to 80 to 100 different jobs that he was rejected from, and he's claiming that all of those employers used this Workday tool and it was discriminatory. So I think a motion to dismiss is currently pending in that case, but it'll be interesting to see what comes of it. All right, I'll pass it on to Shauna now.
Perfect. So now I'm going to talk about creating an AI workplace policy. If you're considering whether or not you should create one, you definitely should. Chances are employees in your workplace are using AI right now, and you may not be aware of it. So things to consider when creating a policy. The first is, what's the purpose of your policy? Most likely, this is going to be providing guidelines to your employees about the use of AI in the workplace. So around what different biases are, what information should and shouldn't be used, but really providing guidelines for your employees. You'll want to evaluate the scope of the policy. So does your policy apply to just employees? Does it apply to vendors and third parties? Does it cover use of just business tools, or does it cover use of personal phones that have access to work email and other work information? So you want to define what that scope looks like. When defining the scope, you'll definitely want to talk to your different stakeholders in your company to get an idea of what AI they think employees will use. So you'll want to involve legal, IT, HR, and really get an understanding of what AI might apply so that you can properly define your scope. You'll want to include in your policy some explanations around what is AI. So we provided some definitions earlier, but it's important that you educate your employees on what AI is to the company. And then you'll want to make sure that your policy addresses compliance with other company policies. So for example, your ethics and business conduct policies, anti-harassment and anti-discrimination, confidential information policy, information on security, HIPAA policies, and vendor due diligence. Are you going to require that your vendors also have guidelines and requirements around use of AI? So in addition, you're going to want to be specific about what AI tools can be used. So you want to think about things such as what AI tools have guidelines and safeguards in place, which ones are licensed by the company, which ones make sense for your business. You want to outline that as part of your policy. You're going to want to list what kind of activities are prohibited. So this likely would be things such as using information such as social security numbers, medical records, financial information. That kind of information should not be used in AI. You also want to prohibit the use of the company's confidential information. As we talked about earlier, if you have trade secrets that you want to protect or other information that you keep confidential to ensure that it's considered confidential, you don't want employees using that and plugging that into AI tools. So you want to make that clear in your policy. You'll want to identify what are high risk and low risk activities. One recommendation is when identifying high risk activities, you can have safeguards such as, to use AI for those kind of risks, they've got to run it by legal or IT and get approval before they can use whatever AI tool they want to use. Some high-risk activities are things that we've talked about already, but screening, hiring, and other employment decisions, that's where we see bias coming in. The use of AI for doing background checks or salary and criminal checks, workplace safety, wage and hour issues, managing remote workers. That's something where you really need to know the details, and relying on AI could be problematic. And then really anything that uses personal information or your client information. Low risk activities, this again is going to vary from workplace to workplace and by industry, but some examples are marketing, creating social media posts, summarizing articles or documents for you, research. Those are all low risk activities that AI can be used for. And then we've already kind of talked about what tools are permitted. You're going to want to have your policy lay out requirements for the use of AI. So one is independent validation. Your employees are going to be expected to take certain steps to validate the information that they're using to make sure that they're accurate, they have integrity, depending on what industry you're in. If you're in the legal industry, it needs to comply with legal ethics, be at an acceptable level, just as if you were performing the work yourself. Transparency, again, we kind of talked about this, but you're going to want to be upfront that you're using AI. You're going to want to be transparent about how that AI is being checked and quality checked. AI audit tools. So you want to also explain how is the company going to audit what is being used in AI. Are there going to be checks? Will there be mandatory training? So before using AI, our employees going to be required to learn about those AI systems and what can and can't be used. Your policy should also explain how non-compliance should be reported. So if an employee learns that someone is using AI for an improper purpose or disclosing confidential information, who is that reported to? Does that go to legal, IT? Put a process in place, as well as violations for the policy. If an employee is found to be violating the policy, will they be disciplined? What does that discipline look like? Could that go up to termination? You're going to want to be clear about that as well. And then acknowledgement. So it's going to be important to have a policy that your employees sign off and acknowledge that they've read and understood the policy. And that really will help just prohibit problems moving forward, making sure that everyone is on the same page on how AI can be used in the workplace. So that's a quick overview of workplace policies. Again, definitely recommend that you put one in place, that you have these discussions with your employees on how they're using AI, what tools are out there that can help your workforce make things quicker and faster for your employees, but do it in a way that's safe and keeps your confidential business information contained as you would like it to be. So with that, I think that wraps us up on our AI section. We'll go ahead and turn it back to Ashley to close out the presentation for today.
Thank you, Shauna and Owen, for that engaging presentation. It was very helpful and full of good nuggets of information for all of us to think about. I want to thank all of our attendees for joining us today. We really do hope the information was helpful to you and your organization. Just a few quick reminders before we sign off. The program that you just participated in is pending for HR and legal education hours. And in order to report your hours, just click on the CEU icon at the bottom of your screen. And then a certificate of attendance, including a course number, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And then finally, just one more ask. If you could please complete our short survey. Like I said at the very beginning, a couple hours ago, this is the best information we have on what information would be useful to you in future presentations, and we really do take it into account. So with that, our program is concluded. I hope you all have a good rest of the day, and thank you very much.